important in legal teaching and research. So the topic for today's discussion is importance of outcome-based education in legal teaching and research. While I have taken this topic is that just before like 1 month ago, I have conducted an international FDP on this outcome-based education. And I have got the inputs from various national and international professors that how this outcome-based education is an education policy and various institutions where they have COPO mapping and everything. So what this is all about, why we need to all do all these things? Why can't we have the traditional method? This is the syllabus, this is the book, go and read it, and let's come and have an exam. So instead of that, now we are more towards the student-centric zone that our students should be benefited from the slide which I prepared for you all so that we can have a good connection here. Just give me a second till the time share. I hope it's
Yes,
okay.
Preeti,
Yes,
all
ma'am. All right.
right.
All right. So all right. So speaking towards the topic, I'll just start by one statement which Benjamin Franklin has taken that tell me I may forget, teach me I remember, involve me I learn. So it's just a statement, but it conveys a lot of different meanings. For example, you have a student before you. You are going to the class. You have your prepared notes and everything. You are just in front of the class. You're standing on the podium, giving the lecture and asking them to write it. So you are telling them, you are making them right, but I don't think that the students will remember throughout. So they may forget about your 1 week, about 1 month. So next time when you will enter the class, obviously they will not be able to answer you because they have not understood it. Second is teach me I remember. For example, you ask them to memorize it, and they can memorize it for like week or a month or a year or for exams, but for life they will not understand it. But involve me I'll learn. For example, you are taking a class on the law of contracts. So if you are just telling him that the agreement enforceable by law is the contract given under section 2H of the Indian Contract 1872. So it will be just a statement to them and they will not be able to understand it till the time you involve them. Like, what is this all about? Why we are saying that this is an agreement or this is a contract? So once you give them a daily life example, for example, your parents say you something to do, it is not a legally enforceable contract. It is just like domestic relations and they are making you to do something. You may not have legal remedy for it. But on the same side, if you are telling them, if you're going to a shop and you are talking to a shopkeeper, you are saying that I want to purchase this item, whether it is an invitation to offer, whether it is an offer, and at what stage the contract will be or agreement will be like we are not just giving the inputs, we are worrying about the outputs. So this is just a statement from which I have started so that we can understand why the understanding is more important than remembering the things, why the involvement of the students is more important than that is outcome-based education. So this outcome-based education is nothing new. Traditionally, if you talk about the approach, it is not something that we have in this 21st century. It is something which was even prevalent from ages. For example, we talk about the Gurukul system. So even the students were there, they were learning from their gurus. But with the passage of the time, we have shifted towards like making notes and let's giving them this is the book, this is the material. But nowadays we are shifting more towards this outcome-based education. Why? Because right now we cannot go to the class and give them the lectures. That is sufficient. You have NAC rankings, you have various rankings that say that this education institution is best or this is in at so and so position. Why that is required? Because there it is seen whether the education is there, what is given there is outcome or having outcomes or not. So how to decide what could be the outcome-based education? So for that, I've just, if you can see in the slide, I have written few points and I'll try to elaborate on everything so that I can make you all understand why this outcome-based education is very important nowadays. So this outcome-based education, as I told you, this is a new educational approach which we are taking. I think most of the faculty members who are present here must be knowing that we have university. University had some vision. University had some mission. We have certain programs in the university. For example, for example, BLLB honors, then there will be CET decide. Now, he will be able to do after completion of his BLLB honors. So there will be certain program outcomes. Now, based on that particular program outcomes, you might be deciding later on the particular course outcomes. For example, we have law of contracts. I'll be taking one subject so that I can make you all understand in that line. So when we say law of contracts, obviously we'll be having certain course outcomes that what our student will be able to do or will do after studying this law of contracts. But this course outcome should not be different from or should not be different from this program outcomes. There has to be a sync between the program outcomes and this course outcome. That is called the COPO mapping, which most of the faculty members nowadays are doing in various institutions, because this is the need of the hour. We are far away from that traditional approach. So this particular outcome-based education, which is a new approach towards education, it focuses on defining desired learning outcomes or result. Like before going and teaching in the class, we have our set standards that if we are teaching this subject, why we are teaching this subject, what outcomes we are expecting from teaching this subject, and what could be the result after the student will be taught this subject. Now, for this particular thing, this is the design that we can only have. For example, when you submit your PhD, when you do your PhD, you have certain synopsis. So it's more like a synopsis that we prepare that, for example, if we teach law of contracts, our student will be able to do so and such things in the future. So for when we have decided this particular outcomes, now the next comes how we will test it. So we will have certain methods, certain assessment criteria, and certain curriculum. Now, curriculum is developed beforehand. We develop the instructional methods beforehand. For example, we will have lecture-based class. We will have this presentation-based class. We will have classroom discussion. We will have debate and discussion. Then after that, we will also see what could be the various assessments that we will follow, whether we were able to do in that particular class or not. So we may have our midterm examination. We may have our end term examination. We may also have internals. It's the choice of the teachers most of the time in various institutions, where we can decide that the students need to submit the project, the student needs to come up with the PPT, students need to do some field work, or he can come in the class and deliver some lecture on certain topic. So by all these things, we are not only making him to learn the things, to remember the things, we are making him to understand the things, right? Because it is the job of the teacher to teach their students. But when we are giving a topic beforehand to our students and asking them to come to the class and be prepared and give a lecture on it, maybe a 5 or 10 minutes. We are not saying that you have to take a lecture for all 1 hour of the class. So in that case, we are preparing our students where they are also professionally developed. Because like most of you must have seen, it's a fact that some of the people have very good knowledge, but when it comes to delivering, they fail. And some of the people are not much well versed with the concept, but they know how to deliver. They can make the student understand, yes, this is the contract. But we will have two teachers. One will come to the class, will say an agreement enforceable by law is a contract given under section 2H. And he may ask in the examination where what section 2H says to you, or where it is agreement enforceable by law is a contract is given. So this is one aspect. This could be in the traditional approach, but nowadays we need the need of the hour is to have the teachers which make them the student understand, which give them the live examples, which can give, make them face the real world problems, and how they will assess. For example, then you will give the problem based question, so that your students, instead of mugging up the things, instead of memorizing the thing, also able to understand it, also able to apply the principles which are going to help him after his BLLB honors course, or after his this particular course of law of contract. So all this is done because we want to achieve the outcomes that we have decided for our students. So this is called outcome based education. We are giving the inputs and we want the outcome from our students. It is not the salary or something that is the outcome of a teaching. It is not something. It is the incentive which we are giving for our work. But the outcome is how our students are being doing after this particular completion of the course, or you can say particular completion of the program. So this particular outcome-based education is coined by Dr. William Spady, and he's an American. So he coined this term, what is an outcome-based education. So you must have seen the system of education which is seen in the developing countries is different from the developed countries. So that is something which makes us distinct from the country to country. Now, moving forward, if we talk about OBE, in short, it is outcome-based education. It is something that I was telling you that what students should be able to do or they know. Means after the completion of the particular course, program from any university or after the completion of any particular course from any university, what our students should be able to do or they know to do. Means this is the something that they are getting from the course. This is the learning experience. It is not that our teacher was coming and making us write hundreds of pages in a semester. This is not required nowadays if you want to follow this outcome based education, right? So next, what we have, what elements should we think that we can approach towards this outcome based education? What things we need to be very clear in our mind, very clear with the university's vision and mission, be it any university. I'm not saying that some university is good or some is bad. I'm saying any university, any institution, or any educational institution need to keep in mind that we need to see what are the elements by which we can proceed towards this outcome based education. So I'm proceeding, but if somebody has any doubt in between or somebody has any question, I'll feel glad if you interrupt me or you ask me any question. You should have before in your syllabus or in your particular course, that what are the outcomes that you are expecting from this particular course, and they should be such a nature which you can measure. It's not something that is quantity. It is sometimes by your examination, it is sometimes the internships of the students. So first of all, you should be very clear while defining the learning outcomes. So this has to be done before you enter the first class of your particular semester. All this is required beforehand, right? Next is designing effective instructional methods. For example, you have your learning outcomes, you want this particular outcome from the particular course, but what are the methods that you are going to use? It can be different from teacher to teacher. It can be different from person to person. Some says that they will be better if they use the whiteboard and the blackboard. Some say that it will be better if we use the PPT presentations. So it is all up to the teacher. It is all up to the person, until and unless some institution is making it mandatory. I don't think it is mandatory anywhere that you have to use this PPT, although it is sometimes a direction that you should use these things so that the student should be benefited more. So your designing is very important, how you are designing your particular syllabus to achieve your outcomes which you are expecting from your students. Next is how you will implement them. Obviously, for implementing them, you will be going to the classes, you will be using your methods, what you have decided to give the instruction. Then you will have appropriate assessments. So this could be weekly, this could be monthly, this could be quarterly, it could be anything what the institution decides. Some institution do have mid semester, some institution do not have mid semesters. So we are not saying that the degree will not be equivalent. Degree will be equivalent, but the point will be assessment. Some have semester system, some have trimester system. So this is all about implementation, how good you will be towards the implementation of particular course. Next is providing feedback and support. I think nowadays every institution follow this procedure, that they try to take the feedback of the students and they also try to provide the support to the students. Means if, for example, I'm the teacher, I have taught some particular semester. So obviously, at the end of my teaching, my institution will be able to understand whether I was I have delivered good or not, whether my students have understood or not. So they will provide some feedback form, or they will have some mechanism whereby students can give the feedback. So that will also help the teacher to improve more and more. Because teaching is something which is not that you have done your LLB or LLM or you have passed out or you have PhD. It is something which continues till life. And nowadays, I think all the faculty members or research scholars know that teaching is not a job which you do from 9 to 5. It's more like 24/7. You have to be updated. So it's more, for all these key elements, we need continuous improvements. Improvement of our students, improvement of our faculty. Because if we say law is something which is not static, it changes with the changing needs of the time. Thereby, the teacher needs to be updated with the changing things that have taken place in any law. And similarly, they need to update their students, and for updating their students, they need to update their lecture notes, they need to update their slides, they need to update their course material which they are distributing to the students. So this is the key elements which we need to keep in mind while discussing anything about the outcome based education. Now, what are the goals that we are expecting when we say outcome based education? Obviously, once we have the traditional method, That time also the education system was prevailing. People were getting the jobs. They were sitting in the examination. So what new we will do if we have the outcome based education? So what are the goals that we are expecting from it? So one of the important goal is that our students should be well prepared and competent learners. Instead of that, they remember, they memorize. Most of the people will appear for the competitive exams. They can memorize more as compared to the people who are in the corporates. I'm not having a data, but I'm just making it a clear statement that the people who appear for the competitive exams are more good towards memorizing, because that they do for appearing for the pre and other examinations. But when we see a person who is working with the corporate firm or in this corporate sector, you will find that he takes the help of the barracks, because he's not required to memorize. He has the things at his disposal. So the advocates, or you can say the practitioners who are working with the firms, they are not more good memorizers as the people who are doing the preparation for the competition. Second is, we want the application and of knowledge and the skills which our student has acquired during the course, that they can apply that thing in the real world context. For example, if we have taught them contract, they would be able to draft a contract. They'll be able to read a sale agreement or a sale deed or any mortgage deed. So then you make them understand that they are able to interpret, they are able to construct also if it is requiring. So this is something which will only be developed if you make the students to exercise his cognitive faculty, to understand that what he is learning and how he will be going to apply that particular knowledge or skills which he has gained during the particular course in the real world problems. Even if he becomes an advocate, he should know that where this is given, he is not required to memorize what it is given. He should know to interpret, he should know to read the bare act. So if we enter the class, most of his students don't understand in first year what is the bare act. They understand bare act is something like a book. So first of all, we need to make them understand what is this bare act all about, what is this book, how this book is secondary and how this bare act is primary. So this all this thing only happens when you have these goals in mind, when you have these outcomes in mind, that you want your student to be such and such. By this we want to bridge the gap between the education and the needs of the society, what the employer requires, what the professional communities requires. So if you only follow the traditional method, what I'm trying to point it out, you might prepare your students for competitive exams, you might prepare them to memorize, but you will not be able to prepare them to understand. I say 95%, there are obviously the 5% students can memorize, understand, and they can do all the things, but not all. So in total, if we talk about majority of the group, then we say we need to see that nowadays we have people who are more educated, who are more qualified, but we do not have number of such government jobs which require competitive exams. Therefore, we need to build the skills in our students. They can have their own status. They can meet the needs of the employers, which particular corporate firm or this corporate sector is requiring from the particular student. We also need to require to grow them professionally, so that if they are standing before a crowd, they are able to speak, they are not hesitant, they are not like shivering. So all these skills is also to be required to be built during the 5 years of the course. Then what next we require is that we need to do the aligning educational outcomes with the demands of the respective field or disciplines. It's not BLLB honors that I'm graduate in the law. You should have some particular specialization, that you are specialized in this particular thing. Most of the universities now even provide specialization in the 5-year course instead of your LLM, because LLM anyway is a specialized degree. But even the 5 years course, you can see some of the national universities, even most of the private institutions also nowadays provide a specialized 5 year of this BLLB or BBLLB, or even some have started the BSc LLB also. When we have this AI and everything, obviously the science, the computer science is going to play the role, and we need to prepare our students to understand the science behind the law also, right? So now coming towards this outcome based education, I hope I made it clear to the people who are listening me that how this outcome based education is important. What are the various elements that we need to see when we want to draft our education policy regarding to this outcome based education, the outcomes and the goals. So now we are coming to the particular, that is law teaching and research. So most of the people do not understand the difference between what is legal teaching and what is legal research. So what we require to understand is that legal teaching is something different from legal research. A teacher who is teaching any university may also be a legal researcher. And even a legal researcher who is doing research in the fields or working with any institution can also afterward becomes a legal teacher. So there is a thin line of difference which we need to understand between legal teaching and research. And if we are like aligning our outcomes, we have to see this legal teaching, because legal research is something which is not requiring a classroom. It can be like anywhere, it can be done by any person. But with respect to the legal teaching, you are going to get a degree. Even a person who is not a law student, he does his research. It can be a student of economics and he is doing an interdisciplinary research, which is the economics and the law. So he will also be doing the legal research, but he has not been taught by that phenomena that we call outcome based education in law teaching. So when we refer to teaching, obviously we'll apply that OBE, that we need to see that the methods and the processes that we are following, we are using that to educate students. So legal teaching is educating the students about the law, where you are conveying them what are the various concepts, what are the various principles, doctrines, theories, and even you are trying to impart the practical skills by asking them to do internship, by asking them to do a project activity, or by asking them to visit a particular village or see the conditions of a particular village nearby. So by this, you are making them to understand the law and the things that are related to that particular phenomena. So for that, you require a particular educational setting. So if you want to do your BA LLB, obviously you'll be going to some institution, be it regular or be it part-time or be it anything. That is a different thing. But you require a particular setting. So you for that you have law schools, you have universities, colleges, certain educational institutions. This is all about which we do in the legal teaching. Now, what are the methods that you use? I already told you. We may have lectures, we may have PPTs, we may have presentations, seminars, discussion, workshops, case studies, and even the practical, the moot courts, the clinical programs. So all this is required with respect to legal teaching. Why we do all these things? Our aim is that we try to provide the students with a comprehensive understanding of what he is studying, what he is being taught, and also we want to develop the jurisprudence behind the particular subject that we are teaching him. Next is we also want to develop the students that they can be able to exercise their cognitive faculties, they can think critically, they can have analytical skills, they can do legal research. So legal teaching is a tool by which we want the people to do legal research, right? So this is one of the things that we have as an outcome from the particular students. For example, many of the people after doing 5-year LLB becomes the law clerks. So what they are doing the legal research. So we have prepared them by legal teaching that they are now able to do the legal research. So when we talk about legal research, this is an inquiry, this is an investigation, this is an analysis, which we only be able to do if we know the law. So knowing of the law is required, legal teaching is required to do the legal research. Then when we do the legal research, we try to identify the problem, we try to analyze the situation, we try to find out the gap, we try to see that what is the lacuna in any legislation, and then we try to interpret or construct the various case laws, and some we even try to write the scholarly articles. So this is done to gain a deeper understanding of what the legal concept that we have studied. And that is also a part of our programs. When we teach a particular subject, for example, we are teaching the contract, again I'm talking about it, we may ask the students to prepare like an agreement whereby he can go to a shopkeeper and ask for certain things in written form, so that we can understand how a student is able to do the research in that. Now legal researchers also do an extensive literature review, case analysis, they interpret, and they also do a comparative study. So this the people who are the faculties who have done the PhD or pursuing PhD, the research scholar, can better understand that how legal teaching is different from legal research. So what you are doing in the 5 year of your BLLB course, graduation degree, is most of the legal teaching, but some of the legal research. But when you are doing your doctorate degree, is more of a legal research than very little of a legal teaching. So even your supervisor, even your guide is not making you to write the thing, is not dictating you. He's just seeing as a guide that what you are doing is aligning to a particular framework that you require for your research. Therefore, I say that legal research is fundamental to legal scholarship. Means if you want to be known as a great scholar, you should be extensive in the legal research. And it is also required when you're doing the practice of law, when we are making any policy. Therefore, we have these things which we call legal education, legal research, legal teaching, legal profession, or even when we talk about law and justice delivery system, which the courts do. So all this is, or even we have many other aspects also. All this is done to have the continuous evolution and improvement in the legal field. Now, what is this is means we are not a static. We are having progress in our legal sphere also. So when our laws are progressive, then our society is progressive. Why not the legal teacher and the legal student and all these legal institutions? If we have the Companies Act of 2013, which repealed the Company Act of 1956, we are not going to teach 1956 Act to our students, because we also want to match ourselves with the changing legal scenario, or you can say the changing contours of the legal education, for which we all are sitting together and like having a discourse on it. So this is something which we require from every person who is involved in this legal fraternity. And even now more of the people are doing the interdisciplinary research also. So they are also like contributing a lot towards the legal development and legal profession, legal teaching, legal research. And even the courts sometimes also contribute to the development of the law, even if they have certain guidelines. Obviously that guidelines are taken into consideration by the legislatures to draft a law for a nation. So this is something that everyone in the legal fraternity is giving a contribution, therefore the society is progressing. So next is when we are talking about OBE, and we have seen what is legal research, what is legal education, and what is legal teaching. So OBE can have several important benefits and several implications if we use this outcome-based education in legal teaching and research. For example, if you talk about history, if you talk about geography, even if you do not know the practical things, if they are theoretical, it's okay. But law is something which needs the practical exposure of our students. So most of the things they will learn if they do the practice. They are in the internships, but even during the classes, we should try that. We should provide them the. Excuse me. We should provide them some practical knowledge, some practical exposure. So first of things that this OBE will bring clarity of learning objectives for which you are having this legal teaching or a particular law subject, or even a research. Even when a person does a PhD, he has certain objectives. He has certain aims why he is doing that particular research. So this is done by which you can ensure alignment with practice. Means you can make your student to be like able to do the practice whereby he can understand some of the practical like segments of that particular subject, and it will be continuously improving our fraternity, in improving the legal teaching, improving the legal research. And that will also ensure accountability and quality assurance. I think quality, this is required from every institutions, that what quality type of education you are providing, whether it is something teacher centric, whether it is a student centered approach. So one of the example that I have seen from like during this tenure of my education is that most of the institutions are now preferring to have a student centered approach. It's not that teacher is something, if the student is coming to meet you, you will not give them the time, you will say that I am busy or something. If you are a teacher, once you have taken that job by choice or by default, you should have that approach that you should be available to your student. But it is not, I'm saying that it is to be 24 into 7, but it is 9 to 5. You should be able to answer your students. Either you are sitting in the chamber, or you nowadays you have most of this online facility. You can have the online meetings, you can have the various like Zoom or Meet or something, whereby you can like solve the doubts of your students. It is, again, I'm not saying to interfere into the privacy of the teacher. It is something that the student should also think that teacher is something which is not only available to one student. He has lot many of the students in front of him, so they should also feel that they should take prior appointments. They should see that when the teachers having the free slot, then they can go and discuss. So most of the universities nowadays also have this tutorial class instead of a lecture class. So in a week, if you have 4 lecture classes of a 4 credit course, you also have 1 tutorial class, which is not for teaching, which is more of like discussing the doubts of the students, or if any problem they face, or some of a revision if you want to have. So all this OBE, if you implement in your legal teaching and research, you can ensure the flexibility and adaptability of the course. Means for like, if you are teaching the particular law of contract in the year 2023, now next year if you are going to teach your students in the year 2024, then I think the institutions in my institution it is being followed, that we sit together, all the faculties, we discuss on the syllabus, we revise the course. Now, why this revision of the course is required? Because, for example, you have taught in 2023, you have seen that your course has certain things which are not required to be taught during the class, or which can only be taught by a person who practice in the field of a law. So you can make that particular segment later on into these internships and other things, or the project work, and you can insert more of a substantive thing that you can do during the class in your syllabus. So it is required when if you all sit together, if we can have this course together, if we will get the suggestions and the recommendation, then we can have the flexible syllabus and we can have the flexible learning outcomes or objectives also. And by that thing, we are adapting the changes that are taking place in any society. Now, to understand its outcome-based education, we have the Bloom's taxonomy, which provides us an insight that how we can achieve this thing. Like most of the time, we say we need to have these things, we need to integrate these things, OB in our education. How to integrate? Again, we need to have some structure also. So this is something which helps us to design our instructions, which design our assessments, and we have a hierarchy which is being given by which we can develop the cognitive process of any student. Now, how we can develop is there are 4 steps. From remembering, you can say then we do understanding, do application, we do analysis, we evaluate, and we create. So this is just the steps that are there. I'll tell you in detail what this step is all about, which you can have in your syllabus, because we are almost going to about with the semester. So we can have these things, if not now, then in our next semesters, to make our student more understanding of the things, not just remembering of the things. So you can have the 2 diagrams for you, that is the Bloom's taxonomy and the revised Bloom's taxonomy. So I'm saying that even everything needs a revision. It is not a static. The books we have, they are being revised. So similarly, our laws also are revised from time to time if they're not keeping a pace with the changing society. So if you see the older version, you see, first of all, they should have the knowledge. Now, when they are having the knowledge, obviously, if you compare to the present context, it's just earlier they were noun, now they were verb. So it's more like changing the structure, but ultimately you need to understand what we are talking about it. So once you have the knowledge, obviously you will try to have your students to remember. So knowledge is something which you say that the student should have. Remember something that the student is doing it. Means it is something which an activity. It is something which the student is involved. Comprehension. For example, when you have the knowledge, you will be able to comprehend. Now, what is the term right now we have in the revised Bloom's taxonomy, that we need to understand. If you remember the things, then we should be able to understand. अगर हमें आज याद है that agreement is like agreement enforceable by law is a contract, then we should be able to understand whether it is a contract or not, whether it is also meeting the section 10 ingredients or not, whether it is having the free consent or not. It is not in knowledge that section 2H is only talking about contract. It is the contract which you need to understand section 2H read with section 10 and all other the free consent and the other provisions. So most of from section 1 to section 30 under the Indian Contract Act, you need to understand that it is not only the one thing. If you have this thing, free consent, you will have a valid contract. No, there are a lot of things that you have to read together whereby you can understand. So it is not only comprehension that you are able to understand from section 1 to 30, you are also able to remember and understand it when the situation requires. So obviously, it means that once you remember, once you understand, you will be able to apply those principles of the law when you do any practice or when you have an agreement before you whereby you can read. For example, many of us nowadays go for insurance. Now, if you see any insurance document, if you see by the terms and conditions, I think hardly 2% of the people might read, if you talk about 100%, that what are the various terms and conditions. Even when we download any software, we have end user license agreement. Nobody bothers what are the conditions there. We just click next, 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 and finish. It is set up. Now, if I say, if you read those conditions, obviously it might take a day to understand. But nobody does, because everybody we should have a quick disposal, right? So once we say this thing, even any agreement, if you sit and read, you may have a lot of implications, and you may try to change that thing also. But we want a quick service, we want a quick disposal. It is the human tendency. So application is very, very important. Once you apply your knowledge, your understanding, whatever you have remembered, then you will be able to do the analysis. You'll be able to analyze whether this is so and so. For example, if somebody is being charged for this murder or any offense, There will be two advocates. Same will be having the IPC. Same will be like interpreting the provisions, section 299 and 300. But the point is how they are interpreting for their particular client. Well, one will be interpreting in his favor, one will be interpreting against it. So that is why we say that jurisprudence is something lawyers' extroversion. You must have read when you have gone for this jurisprudence classes that jurisprudence is nothing but this is the lawyer's extroversion. Extroversion means obviously two lawyers. We have this adversarial system. We do not have the inquisitorial system where the judges is having the jury to decide. Judge will only listen to the advocates what they are putting for towards the towards the court, and they judge will decide in one of the favor. So what the judge is doing? He is only seeing what is the lawyers is putting. So there are two versions of the law which are put for before the judge for any offense, and one is in one favor it is being decided. So obviously, if we can say that the lawyers are also helping in the making of the law, thereby it means you are able to evaluate, you are able to synthesize, and by this you are able to create. It's not that you will appear for any government job or a private job or anything. You yourself are competent enough to start your own startup. So that is called creating. That is making your students to create that thing, right? So this is something that we follow from broader to a minute, and this will help to frame our learning outcomes. This will help to design a program outcomes, objectives, and to align them with the course outcomes or objectives. So this is called a COPO mapping, which we do during their semesters for a preparation of a syllabus. Now, when we say these things, what we need to understand. Now, this Bloom's taxonomy, when we talk about remembering, so we should ask one question like within ourselves: can the student recall or remember the information? So once we frame the first outcome of our course, we should ask this question to us that whatever we are framing, what we are doing, we should ask this question: can the student recall or remember the information? So for that, we can see that they will be able to define, duplicate, list, memorize, recall, repeat, reproduce, or state. So our first objective, we can say that after studying this particular course, our student will be able to have understanding of the law of the contracts, right? Next is understanding. The second step, can the student explain ideas or concepts? Obviously, once you have remembered, then your understanding will be checked. So you should ask this question within yourself that once you are designing the second outcome for your course, whether your student will be able to explain the ideas or the concepts. So for that, you should use the words, or you should be able to see that your students will be able to classify, will be able to describe, discuss, explain, identify, locate, recognize, report, select, translate, or paraphrase. Means once you have taught them law of contract, the first thing they should know is they should remember what is law of contract. They should not be confused with contract law and the company law. Then once they have remembered what is law of contract, they should be able to explain to any person, okay, look, this is an agreement and this is a contract. So this type of understanding we require. If anybody asks them what is a contract, they should be in a position where they are enough to make them understand that yes, this is the contract, even if they cannot verbatim explain verbatim as it is given in the Indian Contract Act. Third is the application or applying your understanding, what you have remembered. So for this, you need to ask the question, can the student use the information in a new way? Means you have taught them this is section 2, this is section 210. Can they be able to use this information in a new way? Means whether they'll be able to choose, whether they'll be able to demonstrate, dramatize, employ, illustrate, interpret, operate, sketch, solve, use, or write. It is not only with the law, so it is just for all disciplines that the course outcomes can be defined using these taxonomy. So once you have taught them, your students, about the law of contract, you are able making them able to understand what is contract, then they should also be able to apply that thing. They can be able to demonstrate that why this is an agreement and why this is a contract. They should be trying to interpret. So that is more required when you make them remembering, when you make them understand, when you make them apply their knowledge. Next is analyzing. So for this, you need to ask in your mind while you are drafting any outcome for a particular course, that can the students distinguish between the different parts? Means whether they are able to compare, whether they are able to contrast, criticize, differentiate, discriminate, distinguish, examine, experiment, question, or test. Means if something is before their is provided to them, for example, the client has given them a copy of a document. So if they have studied the IPC, they should be able to identify whether it is an FIR or not. whether it is, for example, corporate law, whether it is a contract, whether it's a sale deed, whether it is a mortgage deed. They should be able to identify, they should be able to make a distinction between a document which is legal and a document which is not legal. Then if you are making your students up to this level, then you are in a position to do evaluation. Means you need to have in your mind, can the students justify a stand or a decision? Means when you give them a problem based situation, for example, you are giving them a situation that is going to a shop and asking the shopkeeper to give a certain item, and so when you have asked to the shopkeeper, they have denied to give you that item. What the legal remedy will you have, whether this is a concluded contract or not? So one of the students might say that when we have gone to that particular shop, if the items are displayed, this is an invitation to offer, and when we are choosing the item and putting it up in our buckets, that is, we have decided to go for this invitation to offer, and the moment we are putting it on the desk of that particular person who is doing the billing, that moment we are making the offer, and the person says it cannot be billed. So obviously he's denying, he's not accepting your offer. So you do not have any legal remedy because you have just made an offer. It's not an acceptance that you have done of that offer of the items that are being displayed, right? So this is one of the things which one student can say. Other students wants to say, or he can answer in such a way that yes, I have gone to the shop, I have given the selected the item, put up it in my cart, and then I have put that thing on the desk of that particular person who is doing the bill. I said I want to purchase this item. He said yes, and you can have. Now the moment he says yes, it means he has accepted my offer. The once he has accepted my offer, I should have the legal remedy in case he is doing a breach of it. So it's the two students using the little information which is given in two different ways by adding an extra facts to it. So once they are adding an extra fact, you need to see whether they are aligning those facts with the particular problem or not. Now, for example, if you are given in the question, you should use only the facts which are given. Second is, you can say that you can suppose the facts which are not, or the other information which is required as per you. For example, you are teaching the students with the company law and you want them to understand what is memorandum. You have taught them section 456, and you have also taught them 2 clause 56, that this is memorandum of association. You have shown them the table A to F of the Company Act, and now they are able to understand what is this memorandum of association. And you made them to practice how to draft this memorandum, and you have given only a few information that this is so and so company situated in India. You have not given where the registered office will be. You have given it is a company having the share capital, and you have given some other facts. Now, if they want to draft, obviously the second clause will require them to state in which state they will have the registered office. So once you have given India, obviously they can choose any state, right? So this is something how your students can answer. But if you tell them define memorandum of association given under 2 clause 56, then you cannot expect anything that where your students will be able to give you some interpretation, construction, differentiation, or even you can say some comparison. No. So once your student knows what is privity of contract, you should be able to understand whether this is followed in India or whether it or not it is followed in other countries or not, right? So if you are making us the students to start from this remembering to understanding to applying to analyzing to evaluating, then you are making your students to be in a position that they are able to create hereby means anything. They can set up their law firm, they can set up their startup, they can do their practice by their own without having any senior. So this is something which is the need of the art. Just forget about that saying that you always need to have some senior to do this advocacy in your family. There are people who are doing their advocacy on their own. They do not have any family backing, or their parents or grandfathers or mothers who are judges or the advocates. They are doing their self practice. So then you need to ask your students, can students create a new product or point of view? So this is when we talk about law, whether your the students can make any suggestion towards any legislation, whether he is able to identify the gap, whether he is able to criticize something, whether he is able to critically analyze something. So you need to make your students to understand that what is the difference between examining, describing, demonstrating, interpreting, constructing. So that's why when you ask a question, if you're written examine, the student should understand what he is supposed to write. When you have written describe, he should understand what he's supposed to write. So most of the students just see the topic. It is being asked, examine the Indian Contract Act or evaluate the Indian Contract Act. These are two different things. So in that line, we need to follow these steps while going further and knowing what is the need of our students. So to sum up, if I'll be doing for the today's thing that we have discussed is that we should utilize this Bloom's taxonomy. We should understand the concept of outcome based education, by which we can facilitate the progressive learning skills, and even we can make our students to think, we can make them to analyze, we can make them to solve the problems, we can make them to understand critically the things. So all this is only possible if you're making them to exercise their cognitive faculties. If you're not making them exercise their mind, we are only like having this concept of spoon feeding. Okay, this is something, you have this note, read it, mark it, and just write it in the exam. So this is something which will only achieve one of the objectives. It will not achieve more of the objectives which we require in the present day era. So when we have this outcome based education, so we should have some encouragement and like encouraging learning. So we should encourage students to learn. We should ask them that they should like do something which is in the practical sphere. If you're teaching them contract or company, they should be able to see the contracts of the different organizations. They should be able to identify when they look up to the website of any company, that what this company is all about, whether it is a company having the share capital, whether it is listed in the stock exchange, and what sort of things it is. It is not only they will go to someone and ask, okay, you have taught me this, now you tell me whether it is or not. You should be in a position to like even ask the like, or counter your teacher. The moment you have a student who is countering you, you should be feeling happy that yes, you have succeeded. It is not something on the reputation or a prestige. How can a student, my student can counter me? Most of us feel very different when somebody asks in a class and we do not have an answer to it, because we are not a dictionary. We also have something, we also go prepared for the class. For example, if I am here, obviously I prepared for this outcome based education and things for made this slide for you. And because if I have not prepared, then I will not be able to like deliver. Obviously the people prepare, they spend 3 to 4 hours for giving this 1 hour lecture. And similarly, if you have someone who is not preparing, is just going free of mind in the class, he'll not be able to answer. So if we compare, then student is doing the 50% of the work, 50% has to be done by the teacher, because what you are doing is only reflective towards your students. So it encourages learners to move beyond simple recall, that is memorization, and encourages the learners towards the deeper understandings, towards the application, towards the synthesis of knowledge and the development of the skills. So in every class, we do have two types of learners, or we can have three types of learners. One would be very advanced, one would be very slow, and one would be in between. So obviously, what is the pedagogy that we are following for the advanced learners will not be same for the slow learners. For example, we for tomorrow we are going to have a class on the topic consideration. Now, if we have the advanced learner in the class, those those students will search it out from the barrack, will sit in the library, will read it for the consideration, and will come prepared with the questions. This is one type of a student. So on them, you need not to work so much. The second, you have the slow learners. You have to like have that stick on the head that you please go and read, go, and even after the whole semester they will not turn the pages of the book. So obviously for them you need to work hard, you need to make them develop to read, to make develop to understand and have the interest in the like education. Some people are only doing this BLLB to attain a degree because they have the family business and everything. They might be like just okay, okay, I want a degree, I can learn and I can write in the exams. It's okay, but you need to see the interest of the people who are there in the class. If only one person is there who's really wanting to study with being a teacher, I think we should do that 100% work, that 50% work, what which we require, even if 100% of the people wants to study. So we should not be selective towards the students. We should be selective towards our methods, towards our techniques, towards our understanding, towards our delivery. So this is something what I wanted to speak to you. So thank you to all. I sum up here, and I have given my contact number and email IDs and my LinkedIn profile where we can get connected. If you have any doubt, you can send me a mail or something. I'll be like feeling good to glad to respond to you. So this is what I was to discuss with you for today. Any questions or anything? If you have, you can ask.
We are open for questions. If anybody has, you can just unmute and you can put across your questions. I saw some hands raised earlier. Your queries are solved. Probably the session was too fulfilling. You you discovered your answers in while.
And Shruti, I think I've shared the PPT with Professor
Yes,
Ajay,
we
so
have
you can
already sent it to
you can
across. We
share
have
it
put
with
it
the
on the
participants.
group.
Okay, all right.
Yes. Okay. Assuming that everyone is satisfied and is, we ma'am has just left you with a good thought, and probably next time when you sit with your course plan, you have a better understanding, a better analysis of your own course structure. A proper design will definitely make your work easy throughout your session, and that is what I can speak about through my own experience, that if you structure well, if you design it well, and if you convey that structure to the students prior to your session, your work is made easy. You actually make yourself your work easy for both students and yourself. A very a session which was complete in itself, which will definitely benefit all the newcomers who are looking forward to join us in this profession. It would be definitely going to help those. um, uh, the wonderful thing that ma'am has done is already that she has shared her contact number. But anyway, in case you in case you fail to register that, you can still contact. You can leave you leave your queries in the group. We can address. Thank you so very much for your session here. We look forward for more of such sessions. From where you left, you can still continue from here, because a better understanding, a good understanding, will definitely make the passage for the young teachers easy, comfortable. So thank you so very much, Dr.
Thank you
Preeti.
so much. Shruti. Thank you so much.
Okay.
Thank you. I should leave now.
I think if there is nothing, yes, okay, yes, ma'am.
Okay,
We
all
all
right.
will join again. We'll take a short break. We'll join again for the next session at just after half an hour. So at 11:30. We all will be anxiously waiting for you to join again. Stay tuned. Okay, thank you.